Hello everyone, welcome to Research Academy. In this video, we are going to talk about CLAT PG 2019 objection. In the previous video, yesterday, we have discussed about some incorrect question and answers regarding CLAT PG 2019. And if you are not sure what are the questions are incorrect, so kindly watch that video. That video is going to help you. In this video, we're going to talk about the objection regarding all the 15 questions that we have discussed yesterday. Sorry for being late, but nonetheless, these objections are very much important for you. That's why we have researched a lot of things and then we have prepared this video. So let's talk about CLAT PG 2019 objections. And before getting into the objections, there are a lot of reasonings have been sent by the students as well. So we have looked into their reasonings and we have taken some part of their reasonings also. So thank you for their support. Without their help, it's not possible to make this video. Now let's delve into this CLAT PG 2019 objections. The first question that we have talked about yesterday is relevance versus pleasure. Justice Blackburn used the term. So basically CLAT answer was given C. Correct answer, as you were talking about answer A or D. What we have researched on that option D would be the correct answer, but nonetheless the CLAT answer is wrong because Justice Blackburn didn't use any term like strict liability. What he did, he just pronounced the judgment while giving the broad explanation regarding the strict liability or action regarding the strict liability. So he didn't use any term. And if you talk about the absolute liability, then absolute liability term later came into the picture, and that was the brainchild of Justice Bhagavati in MC Mehta case. So option D would be the correct option, but nonetheless if you talk about option A, that may be the correct option also, but CLAT answer which is given C, that cannot be the correct answer. Now let's talk about the second question. Now second question, as we have talked about yesterday, voluntary non-fit injury is a general defense, not a defense, particular defense, defense in tort law. Now CLAT answer was given C, that is not a defense, and correct answer A and D. Regarding that, we can say voluntary non-fit injury refers to consensual harm or risk, okay, and it's a defense under tort law and also under section 87 to 89 general exception in IPC. It deals with the acts done with consent. So basically it's more of a general defense rather than defense in tort law particularly. So the option can be A and D. CLAT answer C is wrong. Now let's talk about the third question. The third question, you already know it. Defaming someone by words or by gesture is called in tort as libel or slander. Nuisance, none. So the CLAT answer was given A. It's absolutely B. And the reasoning for that, the slander is an untrue defamatory statement that is spoken orally. That must be slander. And libel is an untrue defamatory statement that is made in writing. Now let's talk about the next reasoning. That is, right to vote in election in India is a fundamental right. Now this question is the most controversial one because in the last video there are a lot of students, they have commented in this particular question whether it is constitutional right or statutory right. So students are not particularly sure about the answer, but we have research on it, and let's see if you are comfortable with the answer, then you can go with the reasoning that we have given, or you can frame it on your own. So let's talk about the reasoning that we have given. Now option C is the correct answer. It's a statutory right. Now why is a statutory right? First of all, right to vote is a legal right under section 62 of Representation of People Act. Now the Rajpala case and the PUCL case that you people were discussing in the comment yesterday in the previous video. So basically those two cases were two judge bench case if you follow it. Okay, there is another in that PUCL case, it's a 3 judge bench case, and that case basically talks about right to vote is a statutory right. So all the links of those cases are given below in the description. Kindly go and check it out. That will clarify a lot of your confusion. And also the students are saying article 326, and 326 basically talks about eligibility. It doesn't confer any right. So the only section that is very much valid, that is section 62 of the Representation of People's Act. Now in the PUCL 3 judges bench case, in that particular regard, so there is one difference that is given, that is right to vote and freedom to vote. So don't get confused with this thing, right to vote and freedom to vote. I hope it's clarified. If it's not clarified, please make sure to comment below. Would love to entertain your comment and see what we can clarify in last one day. Now question number 5, ordinance making power, and you have already known it, that is in legislative power. A CLAT answer was given A, and ordinance making power is a legislative power of president when assembly is not in session. And you can refer any book, whichever book you have, Jain Pandey or B.N. Shukla, whatever book you have, just refer the page number or attach the page number. By any means you can cite the authority. Okay, now let's talk about this question number 6. Question number 6 was the lengthiest question. I am not going to read it, but the students were saying the answer would be B. As usual, answer would be B, and the general reasoning was given. You can get this reasoning from any book also, that is V.K. Ahuja's IPR book or any other book you follow. Okay, so in order to patentable, an invention must relate to a manner of manufacture. Manner of a manufacture should be novel. It should be outcome of inventive activity. It should have utility. Utility, that is the question. Okay, and it should not be contrary to the law and morality. So these are the things or conditions that are very much necessary to give or grant patent to some invention. So that's why you can refer to any other book. You can get it in any book. Now let's talk about the question number 7. The question number 7 was raised by a lot of students, the confusion. The A applied for allotment of 100 shares in B company, and a letter of allotment addressed to A was posted in due time. So the posting of letter of allotment, regarding that CLAT answer was given A. Correct answer, students were saying B. As per our research, option is B, because communication of an acceptance is complete as against the acceptor when it comes to the knowledge of the proposer. In this case, the letter, though put in the course of transmission, hasn't come to the knowledge of proposer. So hence the contract is not complete. And we have discussed regarding this case that Lalman Sukla was Gauri Datta. So that is one case that you can refer in this particular regard. And I hope you have also researched by yourself various cases so that you can refer. Now let's talk about the question number 8. Now comes a question which where students were thinking they were incorrect, but actually they are not, because there are certain reasons behind it that we have given. And the only 7 questions, the first 7 questions that we have discussed already, those 7 questions were the incorrect. So you can refer those 7 questions, and these 7 or 8 questions that I'm going to discuss in the next part, this part is basically students were saying the incorrect, but actually they are not. Okay, so let's delve into that also. John Rawls' concept of justice. So students were saying as it was political philosophy, so both B and D would be the correct answer. But option B is the correct, because John Rawls' essay was written in 1875. So basically this essay was named as Justice as Fairness, Political not Metaphysical. So it is tagline, or the title is Political not Metaphysical. I hope you have understood it why I am saying it. And the essay link is also given below. You can check it by yourself. This essay particularly talks about why his concept of justice as fairness is totally political. Because before his concept of justice, everyone was talking about justice as fairness and is an abstract thing, like tooth for a tooth, why eye for an eye, it should be done. Okay, so it's an abstract thing. There is nothing political in it. He is the first person to pronounce this kind of political nature of the justice. So that's why his theory was quite renowned theory in the matter of justice. So link is given, kindly go and check it out. And the metaphysical is a related word term to philosophical concept. Okay, abstract concept. Now let's talk about the next question, that is John Austin. Now this question we have researched a lot of 5 or 6 books and also different internet sources, but we haven't got the exact particular answer to that. But we have applied our own reasoning, and if you concur with our reasoning, you can go by it. If you are thinking our reasoning is not good, or you are thinking that whatever, if you have found the right answer, you can go with your answer definitely with the backup. So let's talk about the CLAT answer. That the CLAT answer was given C, and we are thinking the answer that were given C was correct. Why? Because it's basically our reasoning, and it's not, we haven't found in any book. Okay, when we talk about the 4 options, symmetrical, asymmetrical and relative, all the terms, if you see it closely, okay, and if you analyze it, all the terms are used in comparison with something. Okay, in comparison, because when you talk about symmetrical, you will say something is symmetrical in comparison with something, and some product or some whatever relationship, or symmetrical, asymmetrical, relative, same. Okay, in comparison to something, you are going to say something. So the only one word is left, that is elliptical. Now why elliptical, that I'm going to tell you now. And whereas sovereignty, if you talk about the Austrian sovereignty especially, that is absolute. Okay, there is no comparison. Now basically when we talk about the word elliptical, when we go to the dictionary and find the meaning of elliptical, we find it that elliptical means that cannot be understood easily or somewhat implied. Okay, so if we talk about the relationship between the sovereign and the society, political independent, okay, political independent society, or as such the superior and the subordinates, then it's somewhat implied. I hope you are agreeing to the point that what we are talking about, the sovereignty or the sovereign, it's somewhat implied. So elliptical means also implied, somewhat implied. It cannot be understand. It is totally abstract. Okay, so that's why the elliptical is nearest to the answer, correct answer. That's why option C would be the right one, rather than choosing option A, B or D. Now let's talk about the, I hope you have got it, and I have told you, if you are not satisfied with this answer, you can check or you can refer to some other things also. And if you have found out something, then mention below. We also definitely look into it. Now let's talk about the another question, that is question number 10. The question number 10 is basically, what defense could be used when an injury is caused to a person due to unforeseen or unexpected events in spite of reasonable care taken by him. Now the students, lot of students were saying inevitable accident and act of God, both are the correct answer. But when we check different books, okay, option A is the correct answer. Regarding that, reasonable care is only talked about while inevitable accident. Okay, when we talk about act of God, there is no element like reasonable care, because it is extraordinary natural forces, due to that it has happened. You need to establish that also. In that case, or in the matter of act of God, you are not going to talk about reasonable care, because it's an act of God. Okay, so that's why you can refer the page number that we have mentioned, the 42 to 45 R.K. Mangi of 24th edition. You can see the definition of Pollock that is given under the inevitable accident, and elements of act of God that is given under page number 45, if I am not wrong. Kindly check it. Okay, if you have any book, kindly go and get it. So option A would be the correct answer. Now let's talk about the question number 11, that is, the following committee cannot hear the individual complaints of human rights violation. Now regarding that, students have some kind of confusions regarding, they were saying correct answer should be A. What we have found out in one day, we can say that option B would be the correct answer. That is the CLAT answer that they have given, because human rights committee may consider individual complaints that allege a violation of an individual rights under ICCPR if the state is a party to the first optional protocol to the ICCPR, which establishes the complaints mechanism. And also option B is the correct, because committee that manages the human rights bodies is a vague one. Okay, so doesn't refer to any particular body, so you can go for the option B better. That's why. Now let's talk about the next question. For Roscoe Pound, jural postulates are to be discovered. So CLAT answer was given A. Correct answer, as you people are talking about, that is B. Now let's delve into the reasoning. Option A is the correct as per our research, is because you can go to the page number 51 of the BM Mani Tripathi 19th edition, where Roscoe Pound quotes that I sought to formulate the jural postulates of civilized society in our time and place for the purpose of systemic exposition of private law in 5 propositions. Now basically the purpose Roscoe Pound state by himself is that elaboration of the private law, this proposition is going to help. Okay, so these propositions are the helping hands of the legislator and the judges. They are going to discover the jural postulates in law for evaluating and balancing various interests and harmonizing them. So you can refer that also. So it's basically the option A is the correct answer. Now let's talk about the next question, that is jus gentium is a body of, that is international customs. That would be the correct answer. CLAT answer is given, that is correct, because jus gentium is that law which natural reason has established among all men, is equally observed among all nations, and is called the law of nations, as being the law which all nations use. It reflects the principles adopted by the nations from time immemorial as opposed to statutory law. Therefore, it comes with the purview of customs. Now let's talk about the question number 14, and it is the last question. In which case the doctrine of severability was extended by the Supreme Court to constitutional amendments? Now here is a bit confusion in the students regarding option number A and option number D, but option number D is the correct answer, because in option number D in Kyoto Holohan 52nd amendment regarding the anti-defection law, this case was dealt. Okay, so option D would be the correct answer. Now these are the options that are dealt and the objections are dealt. If you have any other problem, kindly mention below in the comment box, so that we have also one day we can help you out regarding that. And now there is another question regarding High Court. Regarding High Court, as right answer would be 25, as you people know, but there is no option of 25. So 24 is the nearest option. That was the correct answer also given by the CLAT answer keys. So 24 would be the correct answer. If you want to challenge the whole question because of the incorrect question, you can definitely can, but substantiate with it. So that is High Court's question. Now let's talk about this one very important thing. We are going to make video on the expected cutoff. So for that, please mention your correct objectives, whatever you have made correct after checking with the CLAT answer key. Kindly mail us, or you can WhatsApp us, or you can mention in the comment box, so that we get to know and we can make that video. We can tell you what would be the expected cutoff for CLAT PG. That will help you out, okay, what you are going to get and not. And CLAT PG 2019 grievances Facebook group, we have just created it for those people who have the grievances regarding CLAT PG 2019. I mean 3 to 4 wala, that problem that they had faced regarding their OMR sheet were taken at 4 p.m. So they can join this group, and any activity or any steps they want to take, they can take unitedly, that we have talked earlier. So you can definitely join this group. The link of that group is given below, and don't forget to mention or mail or WhatsApp us your correct objectives or the marks you are getting in the objectives, okay, so that we can make the video that will help us to analyze. So these are the things that we wanted to talk to you. If anything left, kindly mention below. We'll definitely talk to you tomorrow. We have one day left. If you like the video, give it a thumbs up. Don't forget to subscribe our channel to stay updated regarding CLAT LLM, AGC, NET, SET and Judiciary. And until next time, thank you. See you soon.